our commitment to enter into those agreements in a formalized way. The site access and negotiating agreement being considered by your board only authorizes us to negotiate these terms. And as I noted, they will be brought back to you for your final approval. And as such, this action is categorically exempt from CEQA pursuant to section 15306, which is information collection. The approval of the development agreement for the county is not considered a project pursuant to CEQA section 15378A, since the agreement sets forth compensation terms that have no foreseeable impact to the environment. And just for your information, the site access and development agreements have been made available for review through the clerk of the board's office, and they will be provided to each one of the board members. In the future, Costco's ability to exercise any ground lease agreement or rights to develop a project are subject to independent environmental review under CEQA, and it's anticipated and planned that they will be complying at EIR, which will be processed through the Community Development Resource Agency. Through that process, there will be ample opportunity for public review and comment on the project, assured through that land development process. So in conclusion, it's staff's recommendation that given the anticipated revenues from rent, sales tax, property tax, as well as the draw for other retail and commercial developments in the 7-acre site on Willow Creek Road, that we recommend your board's approval of the development agreement, site access, and negotiating terms, and the terms that were presented to the board. And we are available to answer any questions that you may have.
And I think your last point with regards to the environmental review is very pertinent here, because from what I've heard, there's a misunderstanding of exactly when the public process starts, and when, what's next, and will there be an opportunity for the public to comment on the proposed project. So it's good to hear that those lines of communication and that transparency is going to take place moving forward. I'm going to go to my first comment. Supervisor McCoy?
I'm sorry, I actually left my item.
Oh, okay. Then I'll bring it back to the board for any questions at this time. Okay. I know there are probably quite a few folks that want to speak. I'm going to have you line up in the middle here, please, if you would, because we want to get through this as expeditiously as we can. And go ahead and please step forward, state your name, your address, and let us know your concern.
Okay, my name is Renee Berg. I'm the facilitator for the State DeWitt Theater Steering Committee. I currently actually live in Nevada County. I was here for years, and I will get back here, but I do not live in Auburn at this point. We would like, as the committee for State DeWitt Theater, we'd like to see the DeWitt Theater taken off of Costco's site plan before the ground lease terms are even considered by the board. Again, there have been some very misleading statements made by county representatives as to the condition of DeWitt Theater. It is quite interesting that these people have shown us no proof of their claims. We have asked for any reports that have been done on the theater, and those requests have been ignored. Third, if the EIR takes 18 months or however long to complete, what kind of guarantees can the community expect that DeWitt Theater will not be torn down during this process? Music and More Arts Academy's lease expires in November of this year, and then will revert to month-to-month. Can you guarantee that this community cultural asset will not be needlessly torn down before the historical significance is determined through the EIR process? Who knows, there may even be Indian artifacts beneath the DeWitt property, or Costco may abandon the project. Why needlessly destroy a community asset? Finally, all of the performances that Music and More put on require 3 to 6 months of lead time in order to secure the rights to use the materials for a show at a non-refundable cost of $2,500 to $4,000. If Music and More go on a month-to-month lease during the EIR process, how can they plan for future shows? They would lose significant money. Their business would go under. Thank you.
Sure, and I would direct you to speak with our facility services
Chairman Duran and members of the Board of Supervisors, good morning. My name is Richard J. Ramirez, and I am the interim city manager for the city of Auburn. At the direction of Mayor Powers and the Auburn City Council, the Auburn City Attorney will be sending a letter today to County Council with respect to item 7, Costco lease at the Wood Center. In summary, the council respectfully disagrees with the finding of staff that the proposed action to approve the SANA is categorically exempt under CEQA. In an attempt to avoid conducting an environmental review, project splitting, or the act of making an actual project smaller in an effort to expedite and rush to action a project, in fact violates the intent and purpose of CEQA. The lease is in fact an essential part of a larger project, a project that will have significant environmental impacts on the city of Auburn and will disrupt cultural resources. The mayor and city council urges the board not to proceed on taking action on an environmental finding that may not be bulletproof with respect to CEQA compliance. Instead, postpone entering into a lease until a proper environmental review can occur, identifying all impacts and potential mitigations. At a minimum, rather than move forward on an action that may be procedurally flawed, allow the board to become more familiar with what the court has said about project splitting by having county staff return with an analysis on the practice. Prudence would urge the board to move slowly now, to move faster later.